What if I told you that the first black woman on the Supreme Court cited unconstitutional, racist laws in order to attack the Second Amendment? Well, that's exactly what happened earlier today. Not only was Ketanji Brown Jackson oh so confused, but she actually cited the black codes and seemed to defend their relevance today in 2026. You cannot make this stuff up. So earlier today, the Supreme Court heard oral arguments in Wolford versus Lopez. Basically, to sum this case up, Hawaii currently has a law that prohibits lawful gun owners, those with public carry permits, from bringing a gun onto private property that is open to the public, unless they get permission from the owner beforehand. So for example, private property that is open to the public, that might include a grocery store, a restaurant, drive-through, movie theater. In Hawaii, even if you are licensed and have that public carry permit, you can't bring your gun there unless the owner agrees. So that's the question here. Is that legal? Is that constitutional? Or does Hawaii need to do away with this law? Now, the Supreme Court has not yet issued a ruling on this. After all, they did just hear the arguments earlier today, but according to the Wall Street Journal, they appear poised to strike it down. Starting in the middle here, Chief Justice John Roberts said people don't have to obtain the permission of private property owners before going door to door to canvass for a political candidate, and questioned why gun rights are being treated differently than free speech rights. I mean, these are both constitutional rights after all. I don't have to have a sign on the sidewalk before you enter my property saying, okay to come in if you're giving me some leaflet, he said. Justice Samuel Alito said the state was relegating the Second Amendment to second-class status. So obviously, the Supreme Court appears ready to strike down the Hawaii law, but that's when people who are defending it, that's when people who are attacking the Second Amendment got the most desperate. And in their desperation, they cited the black codes to make their point. Now, in case you're not familiar with what the black codes are, I'm going to elaborate on that later in the video, but all you need to know for now is that the black codes are not only unconstitutional, but they are overtly racist. So here is Justice Gorsuch questioning Sarah Harris, the attorney for the plaintiffs.
There's been some discussion about the black codes, and maybe they should be relevant, and maybe we really should consider them as significant here. In fact, they're a dead ringer. Thoughts?
It is 2026, and it is somewhat astonishing that black codes, which are unconstitutional, are being offered as evidence of what our tradition of constitutionally permissible firearm regulation looks like. Those laws are dead ringers only in the sense that this law, too, is an unconstitutional pretext. The black codes were offered, as you mentioned, by states before their readmission to the Union. It is not an indictment of the Bruen framework to say that unconstitutional laws do not count in illuminating a valid tradition. As Bruen and Rahimi themselves say, you're looking for laws that aren't outliers. They illustrate what the national tradition entails. And so it is no indictment, but frankly, an endorsement of our history and tradition that when you look at the founding era laws, they are very different from the black codes, and that these black codes themselves are complete departures from what the laws in Louisiana and other states were like before, which was to allow people to presumptively go about in public on property open to the public without consent.
Thank you.
So the black codes were passed immediately after the Civil War, and basically the South, they wanted to be able to keep slaves, but since slavery was abolished, they weren't able to do that. So they passed the black codes to keep black people basically in near slavery-like conditions. For example, they couldn't freely leave the plantations without permission. They couldn't testify against white people in court. And most relevant to this case, they could not own guns. That obviously is in violation of the Second Amendment. You have the right to own guns, and there's a question about citizenship. We'll get to that again later in the video. So the codes prevented black people from arming themselves. They weren't allowed to buy guns for self-defense or to protect from intimidation or re-enslavement attempts, even from groups like the KKK. Well, shortly after the black codes were passed, they were struck down because they were unconstitutional. People recognized them as being extremely blatantly racist. It was just a short period, a stain on our nation's history. And that's what brings us to today in 2026, because even though the black codes were a blip on the radar, they are the definition of a legal outlier, Ketanji Brown Jackson attempted to cite them repeatedly in order to defend this law in Hawaii. She wanted to act as if these black codes passed the Bruen test. So the Bruen test applies specifically to the Second Amendment, and basically it requires that all cases consider our country's text, history, and tradition of firearm regulation. And there are two keys to this. Number one, you have to look at the textual scope. Does the conduct at issue fall within the Second Amendment scope? And then number two, you have to take a look at the historical tradition. Obviously, the black codes are part of our history, but are they really part of our historical tradition? Pay close attention to what Ketanji Brown Jackson is saying.
Justice Jackson?
So I guess I really don't understand your response to Justice Gorsuch on the black codes. I mean, I thought the black codes were being offered here under the Bruen test to determine the constitutionality of this regulation. And it's because we have a test that asks us to look at the history and tradition. The fact that the black codes were at some later point determined themselves to be unconstitutional doesn't seem to me to be relevant to the assessment that Bruen is asking us to make. So can you say more about that?
Absolutely. Black codes were unconstitutional from the moment of their inception because they are pretextual laws that are designed to ensure that newly freed slaves are returned to a condition of sharecropping.
Okay, let me stop you there. They were not deemed unconstitutional at the time that they were enacted. They were part of the history and tradition of the country. And when we have a test now that's asking us to look at what people were doing back then, I don't understand why they should be excluded.
Because they are outliers. They are by definition unconstitutional. They have
found later,
unconstitutional.
Afterwards, not at the time. And if the test says what's happening at the time tells us what's constitutional for this purpose, why aren't they in?
Respectfully, a law is always unconstitutional. When it's from its inception,
so the history doesn't matter. We shouldn't care about the history then.
We should deeply care about the history, but the whole point of the Bruen framework is as follows. The history and tradition of the Second Amendment are particularly important because it is codifying a pre-existing right. To figure out in sort of common law fashion what the national history and tradition are, you throw out outliers. And I can think of no greater outlier than blatantly unconstitutional laws that flipped what had been the tradition in states like Louisiana. And during the period before those states were readmitted to the Union, for the purpose of trying to reduce newly freed slaves back to conditions of servitude, made it a new crime, new trespass, in order to go about armed on private property. Those are obvious outliers.
All right,
that should not count under the whole point of Bruen.
Mr. Katyal will address it.
And as you hear there, she is just arguing she is in a combative role. And it's because at her core, Ketanji Brown Jackson is an activist. She is doing a political job instead of, judging things based on the merit of the law, based on the Constitution. She clearly is against the Second Amendment, so she's going to cling to whatever she can in order to strike it down in Hawaii, even if that means she has to side with this racist law. Of course, this law is not part of the tradition of the United States. That's not to say it's part of our history. It's obviously part of our history, but we have to look at the total framework here. And it just even in how the law came about, right? Some of the southern states, it began in Louisiana, then it spread to others in the South. They did this to defy the results of the Civil War. They did this to defy the slaves being free. So even in that moment, it had nothing to do with the Constitution. They were trying to find some sort of loophole. And even though it wasn't found unconstitutional at the time of its passing, shortly thereafter, unconstitutional. So just because you make a mistake, that doesn't get to define you forever. Yet Ketanji Brown Jackson wants to act as if that isn't an aberration, but instead the consistent through line in our nation's history. Now, the irony here in all of this is that when you take a look at the history of the Black Codes, they were obviously created to oppress Black people and to circumvent proactively the Constitution. Because don't forget, this was immediately after the Civil War, and there were a lot of talks and discussions about the rights of enslaved people, or in this case, formerly enslaved people. Would they end up becoming citizens? And so the Black Codes were passed to prevent Black people, even if they became citizens, from enjoying the rights guaranteed by the Constitution. So Justice Alito actually pointed this out to the attorney for the defendants. This was quite the palate cleanser after Ketanji's comments.
Mr. Katyal, wasn't the purpose of the laws in the post-Reconstruction South that disarmed Black people precisely to prevent them from doing what the Second Amendment is designed to protect, which is to defend yourself against attacks. They didn't want that. They wanted to disarm the black population in order to help the Klan terrorize them and law enforcement officers in that period, in that region. They wanted to put them at the mercy of racist law enforcement officers. So is it not the height of irony to cite a law that was enacted for exactly the purpose of preventing someone from exercising the Second Amendment right, to cite this as an example of what the Second Amendment protects?
Again, the irony abounds here, and it's not just that. Obviously, the biggest piece here is that Ketanji Brown Jackson appeared really happy and excited and convinced that she had to embrace the historical norm of the black codes in order to strike down this case brought against Hawaii. It's just crazy. Now, my favorite moment of the entire hearing was when Justice Clarence Thomas invoked the 14th Amendment. He was basically like, if you're going to cite the black codes, then why can't we talk about the 14th Amendment? Surely you're going to bring up the 14th Amendment, right? But before we get into that, I would like to acknowledge the members of today's Governor's Club. They are Bob Paul, Super Romer, and Bama Riddenauer. Always great to see all of you. These are people who give tips and super thanks to the channel. I appreciate you being here, and I'm glad that you enjoy. So the 14th Amendment grants citizenship and equal protection to all those born or naturalized in the United States, including formerly enslaved people. So that is obviously relevant to the case, and the 14th Amendment is a lot more important than the black codes, which are just a blip in our history. This is what Clarence Thomas said.
If you're going to cite the Louisiana Black Codes of 1865, don't you also have to cite the subsequent adoption of the 14th Amendment that was in part generated because of laws like that?
Right, so that is exactly our point, that the Reconstruction Congress that ratified the 14th Amendment, this is the unusual case in which you have those folks saying, effectively, Louisiana should come in, and many of the parts of the black codes, including parts that Justice Alito referring to that were racially discriminatory about firearms, were struck from the Louisiana law. But this law stayed in effect. And so, yes, we do think it is relevant history. We don't think our argument depends on it because there's statute after statute from the founding on, and the idea that the number of statutes we've provided isn't enough, I think is very hard to reconcile when you have zero tradition, zero evidence on the other side saying these statutes were problematic. I mean, these statutes are around. You would have thought someone, if this was an infringement on the right to keep and bear arms, would have had a court case, a commentator, anything like what you had in Bruen. You've got none of it.
Well, actually, there was quite, as I said in my McDonnell opinion, quite a bit of discussion of these sorts of laws and the consideration of some that they thought that the Privileges or Immunities Clause in the 14th Amendment preempted these. That's simply my point.
And let's not forget that formerly enslaved people did not have the money or the resources or the connections to bring these lawsuits forward. So even what that attorney was saying just doesn't make sense on his face. I don't know about you, but to me, I just love listening to Justice Clarence Thomas whenever he speaks, because you can hear in his voice. It's almost as if he's thinking, if I have to deal with these stupid people and ignorant people one more day, I'm going to blow a gasket. You can tell he's just like so much more intelligent than everyone there. He's probably one of my favorite Supreme Court justices, at least definitely my favorite one right now. As always, though, all of this is just my analysis and commentary. This is what's happening in the world of politics from my point of view, and I would love to hear from you. So speaking of favorite Supreme Court justices, who is your favorite one right now? And who's perhaps your favorite one of all time? If you have one, let me know down in the comments below. Right now, it would be Justice Clarence Thomas, but of all time, how could you not go Scalia, Justice Scalia? May he rest in peace. If you haven't already, please be sure to leave me a thumbs up. I know it's a simple thing to ask for, but it really does help me reach more viewers like you in the algorithm. Be sure to smash that subscribe button and to check out one of these videos.